capacity and elder abuse. We will be covering one of the most fundamental forms and resources available to help our advisors through the difficult situations that might come up related to diminished capacity, that form being the trusted contact form. My name is Jake Fector, Compliance Manager, and we will dig in. So first, what is a trusted contact form? Breaking that down, it's a type of document that gives the advisor, a custodian, the firm, someone representing the client, some type of advance permission to reach out in the event something happens or changes in the client's abilities. Some ways we've listed on the screen could be physical abilities, so a client becoming disabled in some way, mental abilities, some type of memory loss, psychological abilities. We see that if someone loses the ability to solve basic problems or learn new concepts. And then finally, cognitive abilities. A client may be being confused with time or place or seeing some type of decline in basic judgment. It's important to note that this document is not a formal power of attorney. It's not a legal document. It really just allows one party to contact someone that the client does trust when and if necessary, if they do face some type of diminished capacity or elder abuse situation. So there are multiple forms of the trusted contact form. Each custodian has their own version of this form, and we're actually going to go through those examples at each of our three primary custodians first. So starting first with Schwab, again, their form is available here on the screen for those Schwab clients. They're unique in that technically this Schwab form does actually allow the investment advisor of record, which in this case would be Buckingham, to contact the trusted contact person. So again, they're unique in that this one Schwab form could, again, technically be utilized if we had it on file and say we didn't have our own Buckingham version of the trusted contact form available. But again, this gives Schwab, in this case, the ability to reach out to their clients when and if something does happen. When we look at our other custodian partners in Fidelity and TD, we do not have that ability. So the way that their form reads here on Fidelity on the screen, we do not have sort of that transfer of power as our advisors at Buckingham to say, hey, this client has a trusted contact form with Fidelity. We can just use that when and if we have a situation that actually doesn't qualify when we're working with clients on the Fidelity and TDA platforms. You'll see here again, TDA does not grant the investment advisor, in this case Buckingham or any of our advisors, the express authority to reach out to their client. So in sort of summary here, the custodians do have their own versions. They have their own controls and policies that they need to follow by requiring clients to sign this. And so technically, as sort of the time of this recording, Schwab does allow Buckingham to utilize that trusted contact form when we're working with our mutual clients. Fidelity and TDA do not have that same authority. And so sort of our internal policy, our best practice is to just go ahead and get Buckingham's version of the form signed, regardless of where a client may custody assets. Someone might switch custodians. They might bring on assets across different custodian platforms. So again, best practice at this point is to go ahead and just get Buckingham's version signed, which we're going to go through next. So Buckingham's trusted contact form, again, gives the firm, gives our advisors, gives our representatives the ability to reach out to a third party that the client has instructed us as someone that they trust, someone that they have a relationship with. And again, when and if something does happen in an event of diminished capacity or incapacity for a client, this gives us the ability to reach out to that contact. This form is available on resources. One reason that we are pushing advisors to get this form and why it's become a prevalent task within our industry is privacy-related concerns that if someone were to reach out to someone that they may believe to be a trusted contact without the proper authorization form in place, we may actually be violating privacy law. Thinking about that in a client situation, let's say we look at a client profile and we know that they have a client, for example, might have someone that they've talked about in a client meeting, but for whatever reason we didn't document and get a trusted contact form on file that actually gives Buckingham the express authority to reach out to this person. We might think that we're reaching out and trying to help this client in a time of need, but again, if we do not have this form in place, we may actually be violating Regulation SP at the SEC. And so again, we want to avoid any type of privacy concerns and just want to make sure we get a signed contact authorization form and a signed trusted contact form for clients before reaching out to someone when and if we need to do that. When we talk about implementing this form, it's best practice to collect the form as initial onboarding or part of any regular progress meeting. So this should really be in your advisor toolkit. When you're meeting with clients, you should track this and make sure that, again, cross-reference potential older clients who may not have this in place. Obviously, they're a higher target when we think about diminished capacity. Storing these documents at this time, storing them in a local S drive, sending them to Buck Scanner so we can get them in DocuWare is also best practice here. We also want to try to memorialize this in Salesforce. We're hoping to build up more workflows that sort of help us get a firm-wide grasp on how many clients do have a signed trusted contact on file. And adding this to Salesforce allows us to run those metrics. So when and if you do get a signed form, the AWA or the Wealth Advisor should be going into the Relationships tab in Salesforce and adding that related contact under the family or under the contact of that client. Most folks have been typing in trusted contact. That way we have it linked clearly to know that relationship between the client and this trusted person. It's also recommended to review this person during a regular progress meeting, right? We may have signed a form, say 5 or 10 years ago from a client. Their needs may have changed. They might now have the same relationship that they may have had with that trusted contact at the time of signing that. So always a good practice to bring this form up, to talk about this early and often. Again, because what we want to try to avoid is a situation where elder abuse or signs of diminished capacity start coming up and we essentially don't have any options because we don't have this form signed. I wanted to talk a little bit about the regulatory background of the why behind this form. On the FINRA side of things, there is a requirement right now that they pushed out in 2019, actually in 2017, for FINRA partner firms to make what they believe to be reasonable efforts to maintain and obtain a trusted contact form. Again, that's a loose interpretation of the rule. We haven't yet seen this FINRA requirement make its way to the SEC side, so there's no technical requirement by rule for firms like Buckingham to get this form signed. That's where you see our custodians starting to push for this on their platforms. And again, as of the time of this recording, there's no such requirement, but within examinations, within sort of industry groups that we're a part of, we consistently see the trusted contact form mentioned and utilized as a best practice and being brought up, which is why we want to make sure that our advisors are getting it implemented, getting it signed early and often, and making it a part of their regular progress meetings to make sure that we get this control in place.